Thank you. We've been focusing on the early action items. I am curious, Dr. Sawyer and Ms. Witherspoon, whether there have been any other attempts, lobbying attempts, from current or former administration officials on any of the other proposed actions. Is this something different, qualitatively different?
Well, sir, it's not qualitatively different in the sense that, as I testified, once the walls came down on climate change, we started getting much more direct orders on regulatory proceedings before the Air Resources Board for air toxics and conventional air pollutants. And we were harassed a lot over the formaldehyde rule for composite wood. And when the Air Resources Board actually moved to adopt that regulation, there were angry phone calls after the board hearing. Why on earth did you do that? We thought we told you we didn't want that regulation adopted. We think it's too stringent. We think it's going to hurt business. And we had been broadcasting that it was a rule under development for 7 years, that there were industries who could comply and industries that needed to change. The 3 other countries had already done what we were proposing to do, and it was completely appropriate. Likewise, on the rule for construction equipment, we got a lot of pressure from the governor's office and from sister agencies, Caltrans and DT&H in particular, to ease the regulation and its impacts on businesses. And now I need to tell you, the Air Resources Board always puts as much flexibility into a regulation as it can while still achieving the health objectives. And so we had already balanced a number of factors. We had already delayed control requirements for small and medium businesses, but that wasn't good enough. They wanted the largest businesses to get until 2025 and have lesser control requirements. So yes, it became a pattern across all regulatory efforts.
I just have 2 more questions. One has to do with regulating bodies in general and what you would think of ex parte rules that would govern disclosure or prohibition of certain kinds of contacts. Would that inhibit your work, or would that assist in terms of transparency with the public, especially on this issue, AB 32, and all the decisions that have to be made and the import of them?
Let me understand. You're suggesting that the ex parte rules be extended to the governor's staff?
Mm-hmm.
Well, I firmly believe in open meetings. I think there may be appropriate times for exchanges of the governor and his staff with the rest of the executive branch. But anything to open up the process is fine. Go ahead, Catherine.
Well, the ex parte rules that the Air Resources Board abides by are in the 45-day countdown prior to regulatory action, and any communications during that period of time must be disclosed at the board hearing. There is a little bit of ambiguity about when it's non-regulatory as early action measures. The list was non-regulatory. Whether the case law still applies, whether those contacts needed to be disclosed. There was a very active discussion going on at the board meeting between some members who had been contacted by the governor's office and asked our chief counsel, do I need to disclose on the record that I just got this call? And the decision was made on the spot. The case law was ambiguous, and so they didn't necessarily have to. What I do think the committee should avoid is turning the Air Resources Board into a body like the PUC in quasi-judicial proceedings or the CEC, where everything is just so overgrown with process and procedure that you can't talk freely and work through issues, because ARB is known for its excellence, but it's also known for its very thorough public process and the engagement of all stakeholders, and they would be, I'm no longer there, severely constrained if they weren't allowed to continue having those open meetings and one-on-one discussions with stakeholders and others.
So disclosure would be the preference, if you had a preference on this.
Disclosure in the 30...
Clarifying to whom these rules apply.
Well, disclosure about important contacts in the 30 days before a non-regulatory item and in the 45 mandatory item. That's what I would recommend.
I just have one other question for the administration, those who do the short straw, clearly.